Good evening, and I welcome you to your transformative program, Politics and Beyond. My name is Emmanuel, Jr., the Chief Crusader Against Corruption here in Ghana. And as always, you can get interactive with us using our social media handles and then the WhatsApp number that will be exhibited on the screen for you. You remember somewhere last week, in fact, last week specifically, we had a conversation regarding the Akwatia by-elections. And I want to use this platform to congratulate the NDC for winning the elections and to also congratulate the MPP for showing resilience and putting in the best that they could. Clearly, their best and tactics was not enough. And so I want to congratulate the winning team, that is the NDC, led by the national chairman, Mr. Johnson Asedu Nketia, and his formidable team. We want to say kudos to them. Again, last week, you remember we had a communication coming from the presidency exactly a week ago regarding the dismissal of the then suspended Chief Justice of Ghana, Tokonu. And I gave a brief comment on that. Today, we're going to have a conversation because after the dismissal, there has been so many communications around it. There has been so many commentaries that has come, some leading, some misleading, and all that. But as you are aware, this is a platform that gives you nothing but an insightful, educative program. And that is the reason why we thought it wise to bring it to you again this evening for us to interrogate the whole situation surrounding the dismissal of the now ex-Chief Justice Tokonu. And so this evening, the conversation is going to be centered on the topic from the bench to the box. And we are looking at holding judges accountable. Now, anytime we talk of judicial accountability, we are just referring to mechanisms and institutions that have been put in place to ensure that the conduct and performance of judges are monitored, and also to establish three key things. The first one is the misconduct, corruption, or the incompetence of judges. And so anytime you hear judicial accountability, that is exactly what we make in reference to. Again, it holds judges accountable, and it has three main purposes. One is to ensure judicial integrity. Over the past period, there has been communication to the effect that, or even surveys to the effect that Ghanaians are losing confidence in the judiciary. And so when you have a system that leads to judicial accountability, it's supposed to ensure judicial integrity, upholding the rule of law, and most importantly, maintaining public confidence, as I indicated earlier on. Now, after looking at this, or looking at the mechanisms and the institutions, it is important for us to look at the three key avenues that ensures judicial accountability. And the first one, which all of us knows because that's the basic, that is what holds the entire accountability process, has to do with the Constitution, the legal framework of Ghana. And I'm making reference to our Supreme Constitution, that is the 1992 Constitution. And when, again, we are looking at accountability when it comes to the judiciary, there are two key articles that you cannot do without. The first one is Article 127, which guarantees the independence of the judiciary, but also provides mechanisms for disciplining judges. The second one is Article 146. Article 146 outlines the procedure for removing Superior Court judges. And when I make reference to Superior Court judges, we are talking about the High Court judges, the Court of Appeal, we are talking about the Supreme Court judges. And so Article 146, Article 127 are the key frameworks that we can look out for, or the key legal provisions that we can tease out of the 92 Constitution that deals with judicial accountability. The second one is the judicial, what we call the Judicial Council of Ghana. Of course, when you look at this one too, the Judicial Council of Ghana, this was established under Article 153 of Ghana's 92 Constitution. And so we are looking at three different provisions. The first one, 127, the second one, 146. But we are looking at the Judicial Council of Ghana, which takes its authority from Article 153 of the Constitution. It is responsible for disciplining judges and magistrates, making recommendations on judicial appointments, and ensuring efficiency and integrity within the judiciary. It is also responsible for disciplinary powers. So the council can take disciplinary actions against lower court judges and magistrates, not the Supreme or Appeal Court judges as I indicated earlier, because those ones are handled under Article 146. So that is also the second avenue. The third one has to do with complaints and investigations. So these are the three avenues or mechanisms put in place to ensure judicial accountability. Complaints and investigations. This is an avenue where citizens like yourself, myself, where we have lawyers, we have institutions such as Crusaders Against Corruption Ghana, Imani Ghana, and the others, can file complaints against judges for one, either corruption or corruption-related matters, abuse of power, bias or unfair conduct, incompetence, neglect of duty, and it is also, this avenue also ensures complaints mechanisms such as, it gives you the step-by-step or it gives you the structure that you can use to ensure that the complaints are filed very well. The first one is that you need to submit a complaint to the Chief Justice or to the Judicial Council or to the Commission on Human Rights and Administrative Justice, that's SHRAJ, particularly when it has to do with corruption-related issues that involves the judiciary or the judges. Now, it tells you that these are the three avenues, as I indicated earlier. Remember, the first provision has to do with the legal framework, and we are looking at Articles 127 and then Article 146, sorry. The second one has to do with the Judicial Council of Ghana, and we are making reference to Article 153. And then the third one, which is on your screen, has to do with complaints and investigations. Now, with all this, it is important for us to appreciate the fact that there are challenges, a lot of challenges that confront this whole judicial accountability process. And the first one has to do with delays in disciplinary processes. Article 146 says sometimes when you are applying it can take years. And so it creates a lot of challenges. Sometimes when you intend, ensuring that the judiciary is accountable, by the time you get to the end of the matter, the case itself would have been, a dead case. And so this is a serious challenge when it comes to judicial accountability. The second one is perception of political interference. Executive influence can undermine the independence and credibility of investigations. And people, this week, the past week till today, a lot of people have made arguments on this, saying that there is a perception of political interference as far as the removal of the former Chief Justice of Ghana is concerned. And I'm sure at the appropriate time we'll dive or go deeper into it. The third judicial accountability challenge has to do with limited transparency. And very often, disciplinary outcomes are not always made public. And anytime you want to have accountability and it is shredded in secrecy, it really creates, difficulty for people to appreciate and understand. So that is also one of the challenges that we have when it comes to judicial accountability. The other one, or the fourth one, has to do with fear of reprisal. And here, some complainants, especially from within the system, fear victimization. Can you imagine going to make a submission? And this, I will quickly make reference to my elder brother, Professor Atuguba. I'm not talking about the judge, I'm talking about Professor Atuguba, who some time ago made an allegation against the Supreme Court of Ghana And he was bad. The Supreme Court judges at a point said that they are not willing to sit on any case that involves him. And so the fear of victimization, and I believe he's not just the only one. There are so many individuals who falls within this. And so when they see the judiciary doing something that is untoward, they are scared to ensure that the mechanisms that I have articulated earlier is, activated. So that fear is there. Now, we should also appreciate that even though we have these fears, there has been instances where we've been able as a country to ensure that the judiciary is accountable. And so I want us to look at some historical antecedents. And obviously we are looking at some landmark cases. You remember in the year 2007, a high court judge was suspended for misconduct allegations. So we've been able, as a country, we have history. We've been able to have that. Again, there was an undercover investigation. I'm sure it's happened in the year 2015 that exposed widespread corruption in the judiciary. Now, out of that investigation, we had 34 judges and over 100 judicial service staff being implicated. 22 lower court judges were suspended and they were investigated. And there were several superior court judges who were removed following Article 146 proceedings. And so we have this. But it is important for us to note at this time that these cases, even though they were turning points, they demonstrated also that judicial accountability can be enforced. And that is very important. That even though we have all the challenges, as I have indicated earlier, surrounding judicial accountability, these cases and many others that I have not mentioned here suggest clearly that as a country, we can, and we have done it before. Judicial accountability can be enforced, and it has been enforced before. Although it is also important to appreciate the fact that whilst enforcing judicial accountability, the rationale behind it, the key rationale behind it, is to expose systemic weaknesses. And this is something of a worry to me, because I have said so many times as an anti-corruption crusader that one reason why we fail as a country to fight corruption is the fact that we are always taking the reactive approach instead of taking the proactive approach. And so even though we have been able to have judicial accountability over the past period, we always fail to expose the systemic weaknesses and to fix them. And so it keeps repeating itself. After that undercover investigation, I can bet you that it hasn't ended. People are still engaging in conduct that do not bring or augur well for the judiciary. And that is a fact. So we have that one also. We need to ensure that after exposing the systemic failure or weaknesses, we are supposed to fix them. Now, with all this in mind, it's important for me to bring to your attention some recommendations for improvement. And the first one is that we need to strengthen internal monitoring within the judiciary. It's very, very important. Structures that will monitor internal affairs in the judiciary. The second one is to enhance transparency of disciplinary procedures and outcomes. If we do not do this, it becomes very difficult. First off, for citizens to even have confidence in the judiciary when they know that, or they perceive that nothing is really being done as far as the judiciary is concerned. The other one has to do with legal reforms. The fourth one is to ensure that we increase training and ethics education for our judges. It is very, 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 very important. And then the very last one is to support whistleblower protections. Unfortunately, I have said it so many times that when it comes to whistleblowers in this country, we are talking about protecting them, the country really needs to do a bit more, because a lot of individuals are afraid, even when they have information, they are afraid to do that. And so that is what we need to do. So these are the recommendations that we have put up there, and we're expecting that, the appropriate authorities will take it up. Now, I believe this gives you a foundation to the conversation we are going to have this evening. As I indicated, we are looking at from the bench to the box, holding judges accountable. I mean, individuals some time back were sitting at the bench and they were the authority. They were the law. Today, we'll move into the next segment that will lead me to activate the phone lines for you to share in your views, share in your comments, and to communicate with us. But even before then, as I indicated, you have the WhatsApp platform on the screen. You can send in your messages, and at the right time, we'll get engaging. Stay tuned.
The average human body mass should have at least 60% water for optimal performance in any physical or mental exercise. We can help you maintain it naturally. Natural mineral water. Simply natural. For bulk purchase, call 0596-273-546 or 0596-273-547. This advert is FDA approved.
If okra na menyisika, edia ye mefui.
Ehin fa na menya bosia, edia tre medjuma yimu.
Kai kra mabre ni yebusia ato taxi fufu. Suhum Rural Bank.
Suhum Rural Bank.
Yema mwakwa baba Suhum Rural Bank. Ye won hyehyɛ ahodo bi te sɛ dwadifo abosia, ekuokuo bosia, susu account, and it does all savings account. Me bada chain savings account, and the keka ho. Suhum Rural Bank was 034229186. Na won so wetu miaka say.
Suhum Rural Bank. Ama ene mayeka una.
Suhum Rural Bank. Entime.
I welcome you back to your transformative program, Politics and Beyond. I'm told that the Blasters have scored 1, and so we congratulate them in advance. And we hope that even if they are not going to score again, they should be able to hold a 1 for us to have a win. I wish them all the best, and we pray that we'll end up having a victorious game. We are still on the judicial accountability, and the topic this evening has to do with from the bench to the box, holding judges accountable. Remember that we've gone through the mechanisms, and we talked about 3 key mechanisms. The first one taking its authority from the 92 Constitution, making reference to Article 127 and Article 146. The second one taking its authority, and that's I'm making reference to the Judicial Council of Ghana, taking its authority also from Article 153 of the Constitution. But this evening, because we are discussing the removal of the Chief Justice being a superior judge, we want to focus a bit more on Article 146. And so Article 146 and former Chief Justice. Now, if you look at Article 146 of the 92 Constitution, it outlines the procedure for the removal of justices of the Superior Courts, the chairman and deputy chairman of the Electoral Commission, and certain other constitutional office holders on grounds of misconduct, incompetence, or stated misbehavior. So these are the grounds on which Article 146 will apply: misconduct, incompetence, or stated misbehavior. The key provisions surrounding or in Article 146. The first one raises a question as to who does it apply to. And as indicated earlier, briefly though, I said that it includes the justices of the Supreme Court, including the Chief Justice, him or herself, the justices of the Court of Appeal, the justices of the High Court. So if you look at it, you realize that these are the superior courts, that we have in this country. So all the justices that we can identify in the superior courts of Ghana falls under the provisions in Article 146. We also have the chairman and the deputy chairman of the Electoral Commission. We have the commissioners of Shraj, the Auditor General, among others. So that is the first one. The second provision talks about the grounds for removal. The grounds are three. First one is stated misbehavior, incompetence, and inability to perform functions. And this can arise from infirmity of body or mind. And so the very moment you fall within any of these three, and you also fall within the first one that has been identified, the justices of the Supreme Court, High Court, Court of Appeal, deputy chiefs and chairman of Electoral Commission, Shraj, and the rest, it means that this applies to you. The other thing has to do with procedure. The procedure per the provisions in Article 146 says that there needs to be a filing of a petition, and it can be done by a citizen or a group. After the filing has taken place, we need to have a determination by the Chief Justice, preliminary determination by the Chief Justice. Then the President forwards the petition to the Chief Justice. When it is forwarded to the Chief Justice decides whether there's a prima facie case. In other words, whether there's some sufficient basis for further investigation. And that is where the determination by the Chief Justice comes in. If no, then the matter ends, or the petition ends. But if yes, then it continues to the next stage, and that has to do with setting up a committee. And so there's also what we call the establishment of a committee. Most often, the committee is made up of 5 members. So we have 5-member committee, which is set up by the Chief Justice, and the composition includes 2 justices of the Superior Courts, 2 persons appointed by the Judicial Council who are not lawyers, and 1 other person, usually a lawyer or legal expert. The committee's duty is to investigate the allegations, and that is exactly what they do. After the investigation is done, it is also their duty to ensure that recommendations and actions are submitted. And so after investigation, the committee submits a report with its findings and recommendations to the President, and it's because it's the President who received it and forwarded it. So the response or the findings must come back to the President. And so the findings and recommendations are submitted to the President. If the committee recommends removal, the President must act accordingly. That is, remove the judge or official. If the committee recommends otherwise, so the committee's work influences the President's action. It is not the President who takes arbitrary decision. No, it doesn't work that way. Now, if the committee does not recommend removal, the process ends and the official will remain in office. And so that is also the processes involved. Then we come to the very last part, or the other part, which has to do with the purpose and significance of all of this process. Article 146. The significance and the purpose of this is that it is supposed to protect the independence of the judiciary and other constitutional office holders by ensuring that they are not arbitrarily removed. 2, also that misconduct and or incompetence is addressed. And the very last one is to ensure that due process and fair hearing takes place. And so this takes us through the Article 146. Having this at the back of your mind, having the very first part of it also at the back of your mind, the phone lines are now activated. We are discussing judicial accountability. We are looking at whether or not we wanting as a country to ensure that we have judicial accountability. We are making progress as a country, or we are not making progress as a country. There have been individuals who have made arguments to the effect that the removal of the Chief Justice is political, and that it amounts to executive interference of the judiciary. The question that comes into mind is that when we are dealing with separation of powers, does it mean that the various arms of government are so autonomous that they are not supposed to be checked? Because checks and balances is also one principle that governs, governance and separation of powers. The fact that we have separation of powers doesn't mean that we cannot check. And that is why Parliament has what we call a committee, Public Accounts Committee, that ensures that institutions that falls within the executive are checked and they are taken care of. The same way, Parliament is also checked most often by the judiciary and also by the executive, and most importantly the judiciary. And that is why it is also important for us to appreciate that we have the judiciary that is also supposed to be checked. And when the judiciary is being checked, do we then say that it means we have executive interference? These are questions that has come. And so the phone lines are activated. I want you, being the audience and also being the my guest this evening, to share your thoughts and your comments with me. But even with that, even before that happens, there's a number of questions that have come through, and I want to go through them whilst we wait to have any caller that comes in. The first question that came when the flyer moved out. Okay, so I have a caller on the line. Your name and where you are calling from?
Good evening, my brother. Good evening from Padilla.
Eben, welcome to Politics and Beyond.
Thank you. And
you are at liberty to speak any language that you feel comfortable with, English or Chi or Ga. At least these are the languages that I can understand. Okay, please go ahead.
Thanks so much. That you brought your program to a dialect that will be free in it.
Right. Thank you.
May our Father in heaven continue to bless you.
Amen.
See, my brother, for me, I'm happy for one thing, and I know we'll get there. And I like the way each and every time when the NDC is in power, they make sure they bring reforms to the judiciary. And as you have earlier indicated, I think there need to be a balance, and each and every arm of the government need to be checked. So for me, those who are saying that was this talk or nothing, it is politics, I don't give them. Let me ask you, my brother, is it the first time Article 146 has been used in this country?
No.
Before you back, in 2012, when John Mahama won his first term, didn't the MPP petition was petition John Mahama, especially I'm not unclear about this Loretta Lampe of embezzlement. Hope you remember.
Yeah, I do.
Is it not the same Article 146 that His Excellency John Mahama used?
That's right.
And later on, the woman was fired, and Charlotte said the former UC took over. So I'm happy. And for me, I will continue to say that our judicial needs to be checked each and every time. We are in this country. Someone will go and say what? A plantain. It is not 10 years. Someone will just even smoke just a puff of weed in their hand. That person will be jailed for what? Then you have a superior court judge, a justice, who handled the thought, I don't know what she knew it's against the rules and regulations. So for me, those who are saying what, there's politics and this and that, we are begging they should give us a break.
Right.
We're in this country for 8 bad years, we're working our movement. When a secular petition was sent to the then president, and it was the same with the former Chief Justice.
Right.
Sophia Cookie. We don't even allow charlatans to even have a look at what the family party did. Now look, John Mahama, the president now, after CJ Tokuma requested for 7 days, didn't he give him what 10 good days?
Right.
So for me, Ghanaians knew why they gave the NDC overwhelming majority. More than 2 days now. So let's continue to reform every sector, especially the judicial, because when if we are able to have a focused judicial, I'm telling you, politicians will be afraid because they know that they can't do anything just like that.
Very well.
So kudos to President Mahama, and I'll plead with I'm concluding. I'll plead with Parliament. Please be bold and make sure that you bring your reforms that will change every issue, so that politicians will also not take advantage. Have a good evening, my brother.
Thank you, my brother, and have a good evening too. So, a question that came earlier. This one says that Mr. Wilson, on what grounds did the petitioner sought to remove the Chief Justice from office? Yes, he's making reference to, I think the petitioner was or is Dan Ofori. I think that's the name. So, yeah, it was on 2 grounds. The first one was misbehavior and incompetence. So on these 2 grounds, the petitioner wanted to remove the Chief Justice from office. Then, do I have a call on the line?
Yes.
Good evening and welcome to Politics and Beyond.
Because Lydia Bokodi.
Nyamia Dom Nanswe.
Nyamia enough for me, no account no man penny the Ambeabwa.
Nyamoho, Ebe, in fact, my neck has
I was in Nancy comedy, Nancy, your home, my main. Mukure na yempesi edeka na penke yepesi ekano kura ekwanya excellency John Dramani Mahama efa soa efa ye mani Chief Justice onka openike ke meseri dia ko bi ni de kwa ko bebo nwa ye wo memu saloto se kura atini kura se ensema yakafa no no yenfa na to ni no kan no kuse enima weni and that's what they are going to do. Among Kenya, no, or come to petition to and the and you might get 12 fun, almost a million. And so when John Dramani Mahama are buying, me and my near Kenya, and my new somebody pick up fun, and between the new one, and then for young people, Krakata. And one more medical 100%
So that's one question that came. On what grounds did the petitioner seek to remove the Chief Justice from the office? And I have indicated that they were on 2 grounds: misbehavior and incompetence, and they find their roots perfectly in Article 146, as I have indicated earlier. This one says that is misbehavior defined in the Constitution? No. If you look at our Constitution, it is not defined in it, as in clearly what misbehavior constitutes. It's not. But you see, in law, you can have what we call conventions. So conventions are able to help you to give meaning to words in the Constitution. I have a caller. I'll come back to this. Caller, welcome to Politics and Beyond.
Thank you very much. Good evening, sir.
Good evening. Your name and where you are calling from?
Yeah. My name is David Agbala. You're calling from Umanjo.
Okay, David, please go ahead.
But so the same business say. Asem we ko so nyina no umampani wodi for asem no mu adobia na. So say umampani fa so nyina, so umampani wo fa so nyina. Inte so see no umampani no de no mu buso umampani o yesisi a mo mu. Mami no me freka o. Mami no ewo no e tro chief justice e wo na chi say oba o ewo no Ghana ha oba be chief justice o Ghana ha. I don't know, Mammy, no, the post back up, Mammy, or the post look at an Nisa at the say, good and Nimase. And one a good Nimase, and one gata, or good Nimase. I think, you say, Oba time.
We touch make after if you say, you so or maintaining or maintaining the naso. Because assembling a buy and among after all the due process we are even out on consonant subscribing in others. But we agree to our work a dear offering in a judge. Your former changes. None or one can chief justice or the two from the TTS. I would hope Emmanuel. Now, the dear or Montpellier, it could be say, no, continue assigning guilty to you. Let me say, or my head is coming to my Paisra, and knowing the area from my M8 and farm mother, and the court. If you say, I can't remember that ever. If you have the government or the confidence, back in judicial system.
Medasipa Ishmael. Medasipa. So I was still talking about the question. Now, if you look at the case of A.J. Chum versus Attorney General Enakwiti, there's a guidance given when it comes to interpretation of words in the Constitution, and it is very interesting. If you have the opportunity, look for that case, read the facts, and then you appreciate the comments that came from the judges that sat on it. There are other questions that have come in, and I want to quickly go through some of them. This one says, "Good evening, Mr. Wilson. I'm Eben from Kwabenya." Okay, looks like Eben is the same person who called. "It seems to me that the NDC has the country at heart." Do you have a caller on the line? Caller, welcome to Politics and Beyond.
Thank you, sir.
Your name and where you are calling from?
Please. Yeah. I said, Madam, the media show me some say, Papa, the Alma media, or my Japade. Maybe or Montani Mahamayano. You can say, Dia, or Dimlaso, can be sent. No come to no not doing that form a unity piano piano. You know the only one guy. Because I can tell you Parliament of Mahama Faso, I am a Jumano. Now we are on the politics, What I hear?
In Pacho didn't be back as a fee.
Because that's your order so the community. The community.
To bet me doom now and I bet me reduce so TV volume no. Within the same.
That's why
Mr. Wayum Pacho you.
No, I just said Obama really did the power. Mama I'm more. Where you Obama Mate, and no. Mate. So this one says, sir, what are the conditions for the removal of magistrates of the lower court? Okay, so remember Article 146 talks about the superior courts or the higher courts. Now, magistrate falls under lower courts or magistrate courts or the judges that sit on the magistrate at the courts. Into no Gina Oma Oba very good. With the Lebanon and Medina Chiba Ghana. You get to see it too. No casa. Go full. Thank you.
Yeah, so Martin, there for petition, Anyway, so there's another question that comes in, and it's quite interesting. It talks about, it says that, does the removal of the Chief Justice justify any conclusion that there's judicial interference? And remember, we talked about this earlier as one of the challenges, the fact that it is the judiciary, it is the executive that activates the process, because the executive that received the petition forward same to the judiciary. This time the chief, the Chief Justice, and then committee is formed and all that. This one is asking whether this amounts to interference.
Our economy, no.
Okay, I'm saying sure. But yes, your point is well noted. You're talking about the Iyoko and also our brothers who we are told that have literally become refugees in the neighboring countries. I think it is one in come at the appropriate time on this platform. But now I was asking, I was trying to answer this question, which talks about, does the removal of the Chief Justice justify any conclusion that there's judicial interference? And I'm saying that no, it does not at all. And so if you get opportunity, go through Ejechum, the case, and you really appreciate it. Now, I'll read parts of the judgments in Ejechum, the case, for you to appreciate this. That will help you answer the question.
Nobody robots from
Hello.
Yes.
Welcome to Politics and Beyond.
Oh, how are you, darling?
I'm doing well. Your name and where you're calling from?
I'm Auntie Florence. I'm calling from Dansoma.
Auntie Florence, Ubetimiaka, say Chiana Ga. Anyone you want to talk?
Bonini, yo,
come on me.
Kako invite the boy. Yeah. They na adobo. Kaya bibaka o kunye bo call lo mi ko je mi ko mi ken lo mi ki. Because no le bo mi sa robot for me ba mobu. Na be no ko mi yo mi ji. Bi Antonio wo papa president here. Me kesa ne ba na ba adri for be ni me no e na me ta bi ko so ni bi. Because handi ne scenario. Ti chief justice sanya ne ka fa ko. Ni assign mo na assign. Assign anya reverse, cut a reverse before it's my demonstration. On about me, your assign, too much na care, but no to let me. But not to look for me, no, not any. Or buy a case on the yeah, the women to face to every could say, and I understand. Sitting there now, say, yes, and I do. Look at Papa now, say, and youth empowerment now. Yes,
yes. You're on an equally what, or Benny, in the subsequent episodes, we'll be talking about that. And there's also one thing here Greater Accra in particular. Ubana ke do ewo hefiai street light tuni. And it is so alarming. We'll be discussing all this in the subsequent episodes. Nofia no ba fi fine. Onu. Nofia no bole you e consume wo fe ye Accra. It's very bad. Kashebe, wabali hisani. Oh no. You don't want. You find a job. You find you makele. You bye. Anyway, that's my country woman. Well, so I'm reading from the case, and I'm making reference to the Ejechum case. This one says, and it's in reference to whether or not there's judicial interference. And this is what the judge said, and I'm making reference to Justice Datiba. He said, and I quote him, "Moreover, the fact that it is the president who establishes a committee under Article 146, Clause 6, to investigate an allegation that a Chief Justice has been guilty of such malfeasance of his or her administrative responsibilities as to bring him within the meaning of stated misbehavior under Article 146(1) does not necessarily imply executive interference in the affairs of the judiciary. And this is actually coming from a judge from the Superior Court of Ghana. Mr. Host, please let the whole world know that Madam Chief Justice Tukono is gone forever. When the first petition was sent, Akufo-Addo, to Akufo-Addo, what did he do? He chose to hide it. God's servant Mahama did what the law prescribed. Madam Tukono, play back your press conference and you will remember that indeed the law is the law and is the law. Also, the former Chief Justice, Gloria Ekufu, should be no, that cannot be possible. I mean, that one cannot be possible, so I'm not even going to talk about that. But yes, that is it. So those are the questions. I think I'll just go through one more question, and then we may want to bring the program to a close. And this one says that in this case, and making reference to the Tukono case, is there any guidance to find the meaning of misbehavior as used in the Constitution? So clearly, I think the grounds for, sacking the Chief Justice is something that is of interest to a lot of people, because we need to appreciate and understand it, knowing very well that it's a platform that educates as well. And so, yes, there is, even though the Constitution does not spell it out. I made reference to the Ejechum versus Ejin and Akwete. And I'll read from that, judgment also. It says that the Chief Justice should not be seen to be manipulating the justice system or promoting the prostitution of the system through meddlesome interference in the judicial work of the judges, and thereby rendering the judges automations in the performance of the judicial responsibilities. And so, I mean, if you go further, it tells you that even though the Constitution does not spell out what misbehavior is or misconduct is, of course, misbehavior, what it is, if you read some judgment that has already come in, you will appreciate the fact that it gives us some understanding as to how to interpret it. There are a number of questions that have come through, but our time is really up. And so at this stage, this is what I'm going to do. As I indicated earlier, this evening's platform was to bring a closure to Tukono's case. And it is important that as we bring a closure to it, we will all appreciate and understand it and be well informed. Because a country that is not well informed is always misled. And I don't want my viewers to be misled on any day in any circumstances. And that is why we brought this to you. And so on this platform, we are bringing a closure to it, unless something mysterious happens. If you look at your vicinity, there's one thing that is of worry, and that has to do with how over the past period, it looks like Accra is totally in the dark. It's a country or a city that you can't even drive when it is past a certain time of the night, like 7, 8, 9, 10 o'clock. You drive in a total darkness. And I'm sure it is the same, not just in Greater Accra, but in other, cities. The next episode, barring anything happening, we'll be looking at the